with Senior Counsel Otiende Amollo.
If it may please your ladyship, this honorable court, I will be brief in this part. I will cover only 3 quick subjects, starting with the issue of the 50% plus 1. Your ladyship, this honorable court, may it be noted that the question of the voter turnout in this election is a moving target. It is a moving target depending on who's speaking and in what circumstances. If you look at the replying affidavit of the chairman, paragraph 30, as of 9th of August at 5 p.m., he says the turnout was 64.6%. That is an affidavit he's swearing way after the fact. The director of elections of that same date, at that same time, in paragraph 21, that is Moses Sunkuli, says it was 56.17 at that same time, looking at the same Kim's kit. It will be noted by this honorable court that at various times, the IBC gives different figures. At one time, it uses the figure of 65.4%. At another time, it uses the figure of 64.6%. It is our submission, my lords, my lady, that the premise upon which IBC proceeds is wrong, and that the reason for this moving target is so as to manipulate the question voter turnout, to come to a conclusion that the 9th respondent met the constitutional threshold when they didn't. I wish to submit, your ladyship, my lords, that Article 138 is very clear, and the total number of registered voters must be specified, and that is the denominator. The IBC did publish a gazette notice that confirms the exact number of registered voters and gives it as 22,120,458. In this court, using what they say is the turnout per the Kim's kit, the figure they are seeking to use is 22,005,541. We wish to submit, your ladyship, my lords, that that premise is problematic. The common denominator to be used is the voter turnout as published in the Gazette, not the voter turnout as per the Kim's kit, which ends up with a moving target. We wish to submit, your ladyship, my lords, that not only is it true that the target is moving, if you look at all the permutations, and this is in the supplementary affidavit of Dr. Edgar Otumba, if you take any of the scenarios and you use any of them, and we have submitted this for ease of reference, because Dr. Otumba covers is between paragraph 5 and paragraph 30, and puts all those graphs. By whichever permutation, none of the candidates then achieves 50% plus 1. Whether you use, remove rejected votes, you add rejected votes, whatever permutation, and there are 7. We wish to submit, your ladyship, my lords, that you then need to come to the conclusion that even though they try to take time to tamper with the voter turnout, they do not achieve that target. The last point on that. Why is it wrong to use the vote turnout as per the so-called Kim's kit? Other than the fact that it's unlawful, it is also illogical. We have 46,229 polling stations. If you were to rely on the Kim's kit, and all 42,298 Kim's kits failed, and only one in one polling station functioned, then it means that if the 700 voters in that polling station voted, the IBC will be telling us that the voter turnout is 100%. That would be the logical consequence of that narration. That cannot be. The voter turnout cannot be something that depends on the interpretation of the IBC at its convenience. It must be the denominator as a percentage of the total registered voters. My second point. My lords, my lady, and I do not want to go too much into this, the question of the infrastructure, what the IEBC called the impregnable military style infrastructure. I think it's been demonstrated that it was certainly not at a military grade. It might be important to note, Your Ladyship, my lady, that the one question they failed to answer was why was there stoppage of the streaming of the results at Bomas? They have not answered that, because that military grade infrastructure was obviously compromised. My lord, my lady, we say that it is bad to have a sovereign institution that is captured by the state, but it is worse to have one that is captured by foreigners. We submit that is the position in this one. Your Ladyship, my lord, the question here, and that's my third and last point, is really very simple. And it's a question that draws directly from Article 138(3)(c) of the Constitution. It is very clear, it is mandatory, that once results are received, the IEBC, not the chair, shall tally and shall verify, then shall declare results. If the IEBC as an institution has not tallied, has not verified, then there are no results to be declared. We wish to submit that at the end of this analysis, it is not a question of whether the chair is a hero or otherwise. It is a question of whether the chair did what was expected of them. It is not enough to say that there are certain regulations by the first respondent which they themselves made and now they wish to rely on to breach the express provisions of the Constitution. We wish to submit, Your Ladyship, that in accordance with Article 141, only if there's a result properly declared can you even move to challenge it. In this case, none was done. Your Ladyship, what the chair is inviting you to do is unconstitutional. This bench comprises eminent persons who are involved in the process of making the Constitution, as some of us on this other side. There's a good reason why we've created constitutional commissions and independent offices. If it was intended to create the chair as what was previously called the supervisor of election, there'd have been an independent office, like the Auditor General, Controller of Budget, like the DPP. But now the chair is inviting you to find that his is some sort of imperial chairmanship or chairpersonship in defiance of the Constitution. We wish to invite you not to accept that invitation to amend the Constitution belatedly. My lady, my lords, at the end of the day, the only question will be, did the chair act in accordance with the Constitution? Is it fair to invite you to find that the other commissioners do not matter? The chair of IBC is a first among equals, just like in this court. There are 7, just like the judges of this court. But the fact, Your Ladyship, you are the Chief Justice and you are the President of this court. Yet the Constitution would not allow you to exercise veto powers over the other colleagues. Why would the chair believe that he can have such powers over the other colleagues? Ultimately, my lords, Your Lady, it is the decision of the majority that must be the decision of the court. And similarly to the IEBC, as we are here today, the decision of the IEBC is that the match that was being played was stopped by the referee. If it was in court, it would be a mistrial. By their own admission, they have said that things happened which should not have happened, and therefore it was not complete. My lords, my lady, in 2017, this court made history by nullifying the first presidential election in this continent, and I think only the second known to me in the world. In this year, it is the IEBC that is making history. It is the first electoral body to concede that they did wrong. I want to submit, my ladies, my lords, that you cannot override that decision. I wish to stop there for now. Thank you, my lord.